Good afternoon, everybody, and welcome to our family support Q&A chat. Today we have our wonderful friends from the St. Louis County Probate Court with us to talk about all things guardianship. They were here last week, and if you weren't able to join us for that session, we will be sharing a link to the recording so that you can go back and listen to it. It was a lively discussion, and there was lots and lots of Q&A, so I'm expecting the same today. I'm going to go ahead and get us launched into our conversation with Commissioner William Gust and Misty Watson, who is also Commissioner for the St. Louis Probate Court. And I don't know, maybe we should do quick introductions again. If there's anything you all would like to say, I kind of already identified who you are. Commissioner Gust, why don't you start?
All right, I'll just be brief here. I'm a probate commissioner in St. Louis County. There's two of us. They're both on the screen today. I've been in my post for almost 3 years, and I'm looking forward to talking to everyone.
And my name is Commissioner Misty Watson. I have been one of the probate commissioners for about 2 years, and I also am looking forward to sharing the knowledge of guardianship that we have as the people here in St. Louis County that hear all guardianship matters in St. Louis County. I just want to remind everybody that a lot of the things we talk about today are specific to St. Louis County. So we've been actively working with St. Louis City so that basically, that the rules and the procedures that we follow are very similar for that. So we have been working with them in regards to joint forms, joint rules, etc. So that it's not any, that the differences between the two jurisdictions are very minor for the public.
Thank you. That's really good clarification. So if you weren't with us last week, we spent a fairly robust amount of time talking about the continuum of decision-making options, because we want to make sure you know that guardianship isn't the only way you can support a person to be able to make good decisions for themselves. So there's a lot of options, from independent decision-making to supported decision-making, powers of attorney, conservatorships, and you can go about those on the earlier recording. We're happy to continue having that conversation today, but our priorities today are going to be to start with talking about what your role is if you have been legally appointed as someone's guardian. And then we're going to move through to successor guardianship and talk a little bit about restoration of rights. So that's the plan for the day, and we're happy to go down whatever path you all lead us. There's no formal presentation, so please start right away dropping your questions in the chat bar, and we'll organize them and get them out. So Misty, maybe you can start us off by talking about what it is expected once somebody is deemed appointed someone's guardian. What needs to happen? What do they need to do on an ongoing basis?
So the first thing you're going to get from this court are two documents. One is the judgment, and the other is your letters of guardianship. So the judgment's going to outline what rights were retained and what rights weren't retained, such as the right to vote, the right to drive, the right to marriage, things like that. So the judgment's going to lay out what rights were retained in regards to the guardianship and whether it's a limited guardianship or not. And then you're going to get those letters of guardianship. Those letters of guardianship, I call them the golden ticket, because they have a golden seal on them. And they really are the document that lets you communicate with healthcare providers, schools, other organizations that may have HIPAA requirements that maybe you weren't able to converse with before. And so they are those letters of guardianship is the first step that you get from this court. Then beyond that, there are your duties and responsibilities as a guardian, which are basically to make placement and medical decisions on behalf of the ward. Those are the main decision-making abilities that most people are granted, depending on the type of guardianships. We have done medical-only guardianships, placement-only guardianships, things of that nature, but most guardianships, you're going to be making, whenever it's kind of that full guardianship that we talk about, you're going to be making, mostly medical and placement decisions on behalf of the individual. And when making those decisions, you are required to make those decisions in what's called the least restrictive environment. So you are required to place the ward not where it's convenient to you, convenient to your family, things of that nature, but what is the least restrictive environment for that individual? And that's a very, very important requirement. And also is a requirement when you're making decisions on their behalf, is that least restrictive environment, and not making not making decisions that it is, that individual is capable of making for themselves. So that's also part of that least restrictive environment, is making those, is assessing what decisions can be made on their behalf and what decisions they're capable of making for themselves. And I'm going to turn it over to Commissioner Gus to talk a little bit about the annual reports and the annual requirements for guardians.
You get the fun stuff.
The paperwork.
So I get to talk about the paper. This is actually, it sounds difficult and official, an annual report, but really what it is it's a 3 or 4 page document, and the court will mail it to you every year. So it's also, so that's, as a side note, it's really important that you keep the court up to date as to what your address is. And if you have a change of address, you need to notify the court. But what this annual report is it's something that you can use. You can just handwrite in the answers. You don't need an attorney to help you fill it out or to file it with the court. Write in your answers and mail it back to the court. There's a few things that this report asks, but here's the general gist of it is we want to know where the ward's living. We want to know how many times you visited the ward in the last year. We will ask for if the ward's on particular medications, we like those written out in the annual report. And one of the most important questions in the report is the ward still in need of a guardian? And most of the time the answer, or much of the time the answer is yes, and sometimes the answer is no. And this is always important for us to know, because if you don't believe that your ward is in need of a guardian anymore, then that may bring us to a restoration situation, which we'll talk about later in the guardianship or in this presentation. But one of the things, we look at all of these reports, so we're going to be flagging them for situations that may catch our eye, and that would be one of them, is if someone writes in the report that the ward doesn't need a guardian. What we may do when we see these reports, if we have something that we have questions on, we may send you a letter for follow-up, or we may set the matter for a brief WebEx status conference, which would be, now we do a lot of this stuff over computers, but the vast majority of these reports we don't ever have any problems with, and we just use them as a way to track everyone who has a guardianship pending over them. Something that's really important, though, is that if we don't receive one of these guardianship annual reports from you, then we will probably send you another notice and ask that you show up at an electronic webinar WebEx hearing, because we want to know why you didn't send one of those reports. This is important for us, and unfortunately, if we don't hear from you and we don't receive these reports, we may have to remove you and appoint the public administrator as guardian, which we don't want to do that unless we absolutely have to. So it's just an important way for me to say, just if you have a change of address, make sure that you contact the court and send us a letter and let us know that your address has changed.
I think that's a good segue into the successor guardians, which is how does somebody get appointed? I know a lot of times whenever I was in private practice, whenever I was an attorney before I took the bench, we would often talk about who was going to serve next. And a lot of parents thought, well, if I'm no longer guardian, the guardianship just goes away, right? And no, it doesn't. Once that person is declared in need of a guardian, the court makes sure that they always have a guardian. So that is something that you want to make sure that you have a clearly appointed successor in regards to that. And there's a couple of ways that can happen. First of all, if there are co-guardians, then if somebody dies or resigns, then the other person will just stay on as guardian. So if you have two people serving as guardian, then it just naturally falls to that other person once you let the court know. You file something called a suggestion of death. That sounds very official, but normally it's just a letter saying this guardian has died. Here's a copy of their death certificate. And so there is somebody, that can step forward. If no one is appointed, then typically we find out about that. It gets set on what's called the show cause docket, which is, hey, we didn't get an annual report. What's going on? And then we find out, well, all the guardians have died and this person still needs a guardian. If no family members have stepped forward to serve as guardian, then what happens is that the public administrator is automatically appointed. So there is somebody that is appointed here in St. Louis County to serve as guardian for the various wards. That's often you hear that being a ward of the state or something of that nature. And a lot of times that's what people see as being a ward of the state. Is somebody that is under a guardianship by the public administrator. So that is if there's no family member or friend or somebody like that stepping forward, or even an organization, because social non-placement social service agencies can serve as guardian as well. And then the public administrator does have a very large caseload. So it is extremely high. He does have deputies, however, that are appointed, and it's often those deputies that have the most contact with the individual and are more familiar with the individual's case. And they are still required to, like all guardians, to physically see the ward on an annual basis. So that is a requirement of the guardian to actually go see the ward on an annual basis. We have made some exceptions this last year for, places that have basically banned any visitors from going out there, that we're able to, take care of that. But, we're able to have some flexibility there. But we do typically require for, somebody to see that guardian is for the guardian to see the ward on an annual basis. A successor doesn't automatically get appointed. That is something I think that's important, that you do need to submit a petition for successor guardian. So if no one's serving in that co-guardian role and something happens to the main guardian and a family member does step forward, there may be some lag time. So often we do recommend if a parent is aging, that they go ahead and if they know that, the sibling of the ward's going to be serving as the guardian after they're gone, maybe as they're getting older, to go ahead and appoint that sibling as a co-guardian so that it's just a natural transition for that. And honestly, so that the sibling could serve in that role. I also had a question about what are some examples of non-placement social service agencies who serve as guardian in lieu of the public administrator. So the only one that I know of that's willing to do it right now is Places for People. And they do it more in people that are mentally ill, but that they believe with the proper supports can be functioning within the community. So that's kind of their criteria for service there. At one time, we were talking to Jewish Children and Family Services pre-COVID. I don't know if they're going to be willing to serve in that capacity or not, but that can happen. We also had a question, and I'll turn this over to you, Commissioner Gust, is can the public administrator be appointed before someone dies?
Yes, the public administrator can be appointed before someone dies it would be pretty limited situations. It would have to be a situation where the current guardian isn't doing his or her job, and for some reason they put the ward in danger. Then you'd have a situation where someone would have to file a petition to remove the guardian. But if the guardian's doing a good job filing the annual reports with the court, the public administrator is not going to get appointed. The other thing I would suggest everyone too is if you're the guardian for someone, particularly for a child, if you're the guardian for a child of yours, I would suggest that everyone, if you have ideas on who you want to serve as the guardian when you pass away, you need to execute a will so that those wishes are expressed. One of the things that Commissioner Watson and I have to do is that if a guardian dies, we have to determine who's going to be the successor guardian. And many times this will be, if no one comes forward, it will be the public administrator. But if more than one person comes forward to be the guardian, then we have to look at something we have to look at the statutes to determine who should be the guardian. And the statutes give certain preferences to certain family members. So if you're the guardian of your son or daughter and you have a close friend or a close family friend who you would want to be the guardian after you pass away, you better execute a will that nominates that person, because under the statutory preference, we would be looking to either a family member or the public administrator before that friend. So I would just advise everyone to see an attorney, execute a will if you're the guardian, so that you can put those plans in place for who takes over when you pass away.
And so just to clarify, in that will, you can state your preferences. It would not replace, though, the needing to file for that paperwork to become the next guardian, correct?
Absolutely. So if you're going to and this goes back to what Commissioner Watson said earlier. So if you're going to nominate someone in your will to serve as the guardian when you pass away, I would absolutely tell them that you're going to do this. And I would also let them know that they're nominated in the document and that they need to file a petition to become successor guardian when you pass away.
That sounds really good. I'd love to circle back just a little bit to talk about the public administrator, because you alluded to the fact that they have quite a large caseload. And I think one of the things that we talk a lot about with families is to be aware that there isn't going to be that same level of personal relationship just because of the lack of time somebody's going to have for them to really get to know your family members' preferences. And so trying to really build some additional supports and find people that might be willing to fulfill that role is a really good strategy if it's possible. And once again, we'll put some information in the chat bar. We're having a workshop next week on building a circle of support so that you can start asking people, not automatically to be guardian when you're gone, but maybe for some small things to start building a circle of people that can help with that decision making. I want to, this is an example.
Real quick, I want to add something else about the public administrator too.
That'd be great.
If the guardian's passed away and the public administrator has been appointed and you're a family member or a loved one of a ward and you want to serve as the guardian, I would tell that to the public administrator, because he wants to do what's best and he wants these people to get the best care that they can. And so many times, and I'm not going to make any promises on his behalf. His office is a separate office from ours and different entities. But I've seen many times where if a family member steps forward and he's serving as the guardian, many times if that family member wants to serve, he will step down so long as the court's willing to appoint that person. And many times, many times we are, we always like it when family members can serve, or even if there are no family members, if they're close, very close friends of the ward that know the ward well and that pass background checks, we will do that as well sometimes. So if you know a ward that you would like to be guardian over that the public administrator is serving for guardian, I would initiate a conversation with the public administrator about that.
Great. We have a couple different questions about divorce and guardianship. And I know that there's probably a whole lot of nuances that would go into making decisions. But Commissioner Watson, can you just talk a little bit about some of the potential scenarios if both parents of an adult are co-guardians and they become divorced, or if they are applying for guardianship, how those decisions might be made?
So if they're already serving as co-guardians and they get a divorce, from our perspective, nothing changes. You're still required to make those decisions in the best interest of the ward. And we really, there are many times when two unrelated people are serving as co-guardians. So, maybe it's sister and mom or things like that are serving together as co-guardians. So we really don't have a requirement that you be married. And we do have times that mom and dad are co-petitioners in cases. And in those cases, even though they're not married, but they are mom and dad, then they can be appointed as co-petitioners if they're able to work together. There are other times when mom and dad cannot work together. And then the first thing we're going to do, if the if it was already addressed pre-divorce in the divorce decree of who makes those legal decisions, we're going to look at that divorce decree to determine, guide who we should be appointing as guardian in those cases. However, if there are times it's kind of child custody battle part 2 in regards to who is serving as the legal guardian. And one of the questions that I did see was, well, which parent would decide what rights are retained and what rights aren't if a guardian is appointed? The answer is neither. That's our job. So our job is to determine what rights are retained and what rights aren't. And that has to do with the person that the guardianship is being appointed over, which we refer to as the ward, their capacity and that individual's ability to understand things such as the voting process, the ability to drive, and their ability to understand a marriage contract. So if one parent is saying, I want to retain the right to vote, and the other parent is saying, I don't want to retain the right to vote, what we're going to look at is really, first, we're going to ask what we call them the respondent before they're adjudicated as incapacitated, what their attorney is saying about their capability to participate in the voting process. So I always do tell people, be careful what you wish for in regards to guardianship, because it is our job to make those decisions and the tough calls. And that's what St. Louis County has tasked us with doing, and the state of Missouri has said you have to follow the statutes, and that's what we do on a day-to-day basis. So that's really up to us to do that. And I also did see a question about, is it possible to do nothing and just wait until a young adult is older? I always tell people no decision is a decision, and that's an okay decision to make. That if you're not sure whether guardianship's appropriate for your child who's turning 18, it's okay to kind of and you should, under the statute, explore other options and see whether those options can work before you go to that guardianship. So if you think your child has more capabilities than a guardianship, then absolutely do that. And then I've seen some questions about restoration, so I'm going to turn that over to Commissioner Gus to talk a little bit about that.
Sure.
Before you do that, I just wanted to ask Mr. Nagast, is that situation is the same, I assume, if one parent believes that a guardian needs to be appointed and the other does not, it's still going to be your decision or the decision of the court to ask all the right questions and gather information to make a ruling on that, correct?
Right. And the parent that doesn't believe a guardianship should be appointed will have his or her opportunity to testify and present any evidence they want to present as well. So we'll take everything together and make the best decision we can.
Fantastic. Okay, so we do have some questions about restoration of rights. And I understand that there have been quite a few people that have sought that out since the guardianship law changed, which I'm very excited about. Can you explain what the process to request a restoration of rights is and maybe what that even means?
Absolutely. So basically what it means is it's sort of a way to I guess a layman way to say it would be to undo the guardianship. In a way, if an individual we made a finding that they were incapacitated or disabled, and that's the language we have to use by statute, and a period of time has gone by and the individual has gained some abilities or has found some new ways to live such that they don't require a guardian or conservator anymore, you can file a petition for restoration. The nice thing about these petitions now, and it sounds like a big formal thing, but they don't have to be. The law encourages us to basically aggressively hear these petitions and set them for hearing. So if we get a letter from a ward, sometimes if you're the guardian, you may not know, but your ward may send a letter to the court asking to be restored. And this happens, and sometimes what we'll do then is we'll usually notify we'll always notify the guardian, and we can set it for hearing. The most important thing that we'll want to see if there is a petition or a request for restoration, and I should specify too, when I keep saying petition for restoration, this can just be a letter to the court requesting that certain rights be restored to the ward. We get these very informally. Sometimes these are handwritten letters from wards themselves. They can also be letters from guardians. But what we'll want to see in any event, whether it's a formal petition written up by an attorney, which we sometimes get, or a letter from a ward, we'll want to see some type of medical evidence that the ward has, in fact, restored some of his or her abilities. And usually this takes the form of some letter from a doctor or an affidavit from a doctor stating that the ward no longer needs a guardian, or the ward no longer needs a guardian to make decisions with respect to the ward's right to vote, marry, or drive, or they'll carve out a specific right like that. And when we get these, we always set them for hearing, and then we'll have testimony from the ward usually. And a lot of times what we'll do is the statute allows us to appoint an attorney to represent the ward. And so we'll do that. And when we do that, the attorney's job is to represent the ward and take the ward's, if the ward wants to get restoration, then the attorney helps that person with that. So that attorney can help the ward navigate the process and get the interrogatories or affidavit or medical evidence and get it noticed up for hearing. Cost is something that usually comes up when I talk about appointing an attorney. If there are assets for the ward, in other words, if there's a conservatorship, then the assets or the cost of appointing that attorney will be paid for by the ward's estate. If there are no assets, then the cost for appointing that attorney will be paid for by St. Louis County. There's a fund set aside by St. Louis County for wards that don't have the money to represent themselves, or respondents who haven't yet been adjudicated wards to have attorneys appointed. And so it's not something that would come out of pocket from the guardian, unless the guardian wants to use his or her own counsel to file the petition, which is also fine.
If somebody wants to have that restoration of rights and they've got the support of a family member or a friend or whatever, is it something that you would recommend that they maybe provide some information to the doctor at a visit so that the doctor has what they need to make that decision? It seems like it might be tricky for somebody.
Absolutely. I would certainly do that. And what I would recommend everyone does in this situation is you can, if you want to contact the court, we can give we can give you a form that you can give to the doctor, doctor interrogatory. I believe they're also on our website. You'll look at the guardianship packet, and eventually we're going to have a special packet on our website for restorations, because we get so many of these, and we love to grant restorations when we can. They're really one of the happiest cases and one of the best things that we get to hear in court. But if you need those documents, you can call the court or you can check our website, and we'll get you the blank affidavit that you can give to your you can give to the ward's doctor. And I would absolutely tell that doctor, I've seen an increase in my son or daughter's abilities, and I would like to petition the court for restoration of some of his or her rights. And I was wondering if you would fill out this affidavit that would be evidence that we would use in that hearing. And many times the doctors will do that if they believe that the abilities have increased. And we see these all the time. I've probably had between 5 and 10 this year, and I imagine that Commissioner Watson has probably had somewhere the same amount. There was a question on there earlier that asked if we ever have restorations 10, 15, 20 years after the initial adjudication, and the answer is yes. Typically, a lot of times the more time goes by, the better, because someone who's had a problem will sometimes find better ways to cope with it, or if they have a mental illness, they'll be able to get it under control with medicine and different coping mechanisms. And many times after 5 or 10 years, we can look at all the circumstances and hear evidence from the guardian and the ward themselves and decide, all right, well, this person has made some improvements and we're going to restore their rights. Now, sometimes what we'll do, if they're not ready for a full restoration, we can do something like a partial restoration. One thing that we can do, and here's an example, if there's money involved, we may set aside a certain bank account with a limited amount of money in it, and the ward has the opportunity to use that bank account for a period of time, and they can if that goes well, then we'll consider a full restoration of the rest of those rights. We can sort of do trial runs with individual rights if need be.
That is such a great example. And we actually try and do those same things on the front end prior to seeking legal representation for somebody. How can we work with them to get their needs met and be able to make decisions? And sometimes that means having a capped debit card so that you can start to learn to spend money, and what happens when you run out without it being a major crisis. And that gives families some comfort that they're not going to get into a big snafu, but at the same time allows that person to learn from some mistakes. I know that if people would have looked at the decisions I made at age 18, I might not be in the situation I'm in today. So I'm grateful that I got a chance to make a few mistakes that I learned from and have an awful lot of people to help me out to make better decisions. I know that in the specific guardianship law, it talks about the rights of voting, driving, and marriage as 3 areas to consider for like a limited guardianship where you would retain those rights. Do people also petition for smaller things like wanting to be able to spend time with friends that maybe their guardian doesn't like, or my guardian's limiting my hairstyle? Or those are some of the things that people bring to us sometimes and say, my guardian won't let me go on a date. This is making me crazy. And I wonder how those kinds of things are approached by your office. Either one of you, I don't know who would like to tackle that. Maybe both of you would like to tackle that.
I will say we don't handle those things typically. So those don't typically get to us. If they do, they're part of kind of a larger evidence in regards to maybe that a restoration action, things like that. We have thousands and thousands of these cases in front of us, and we really do, delegate that decision-making ability to the guardians, but require that least restrictive environment. If we have, or sometimes we do have boards that write letters and express those concerns. And whenever they do, often we appoint an attorney for them. And that attorney looks into whether restoration is appropriate or not, or maybe we'll just talk to the guardian and say, hey, you're stepping out of bounds in regards to your decision making. For this individual that, that you're not there to decide who their friends are or things of that nature. You're there to look at what their best interest is in regards to their placement and, in regards to their health and, kind of make sure that their basic needs are met. Now, can you go over and above that as a guardian? Absolutely. And many guardians do, for which, we're very grateful. But, what the guardian is there for is to make sure that individual's basic needs are met and that they are in that least restrictive environment, as we talked about. I think both Commissioner Gust and I can say that there are certain things that we would say that guardian's not, following the least restrictive environment. Typically, we are looking more at kind of, I would say, probably harsher cases in which maybe somebody's confined to a nursing facility or, something of that nature. That really is more appropriate for a community-based setting. I know I just actually had a hearing on that. And we were able to kind of work together to get this individual back out into the community instead of in a residential facility. So those typically are more of the questions that are being brought to us. Some of that's financial because everybody has to kind of lawyer up in that situation. And so, people think hard about what situations they want to bring to a lawyer and what situations they don't. But we are very much about that individual and that the guardianship statute and following the guardianship statute for that.
Thank you. I hadn't realized that we'd gone over our time so much. So if there is anything else you'd like to add, Commissioner Gust, I want to give you one last opportunity to throw anything out there that you're thinking about, and then Commissioner Watson, and then we'll wrap up.
Yeah, I don't think I have anything additional that I need to add with respect to that last question or anything today, except for I appreciate everyone's time, and I'm happy to do this as long as people have questions and are willing to listen to me talk.
Well, great. I'm sure we'll have you back. Commissioner Watson.
Just the same. Thank you all so much for attending today. We are very much glad to be educating the community about, what guardianship is and how, whether that's helping you make a decision about whether that's the right call for your family or not. So thank you all so much.